is the husband of the deceased, and the FIR has been got registered on the basis of the alleged dying declaration of the deceased. She got recorded her Fardabyan at Milord's Apollo 1 Hospital at Patna, alleging therein that her marriage was performed with the appellant 10 to 11 years before, and she was having two sons and two daughters. Husband, father-in-law, mother-in-law, and sister-in-law all together used to make demand of money, no quantum, money and jewelries. And on account of their demand, on fulfillment of their demand, onwards 25/9/13, all the said persons started making quarrel with the deceased. When in the meantime, this appellant took kerosene oil, poured her upon her body, and lifted fire. This is what the statement, the dying declaration.
Where is that dying declaration?
That is the FIR, the Fardabyan of the informant.
Yes.
By its submission would be that while her statement was got recorded by the police officer in the at Burn Hospital, Milords, there is no endorsement of her fit state of mind, not recorded with consent of the doctor, and no magistrate was deputed. No magistrate was called for, having sufficient opportunity. And after, Milords, the Fardabyan was recorded on 26/9/13. She died 3 days thereafter on 29/9/2013. And the FIR has been got registered on 17/10/2013. That is after 18 days after her death and 21 days after recording of the Fardabyan. The doctor examining the victim has not been examined. Neither the postmortem report nor any injury of the victim has been got exhibited.
And you are in custody since when? Your husband?
Milords, I am in custody since 9/4/2015 for more than a period of 7 years.
9/4/2015.
And the rest, all the prosecution witnesses, who are 7 in numbers, none of them has supported the prosecution case. Rather, Milords, all they have stated that he suffered the burn injuries while he was cooking food. Not even a single Milords witness. So, Milords, the dying declaration of the victim has not been supported either by any of the circumstantial evidence or by any of the evidence, direct evidence. And 21 days delay in Milords sending the FIR to the Milords in registering the FIR. The investigating officer has not been examined. Doctor has not been examined. No injury or the postmortem report has been got exhibited. And I remain in custody, Milords, for a period of more than period of 7 years. Milords,
When was the marriage solemnized?
She said that her marriage was solemnized 10 to 11 years before in her statement. And she was having 2 sons and 2 daughters, who all are alive and residing with the parents of the appellant. The mother and father of the appellant have been acquitted. Do the discharge ticket of discharge of the victim from the hospital has not been exhibited, but my lords, the said discharge ticket says that she had received the 100% burn injury, and her statement, which led to registration of the FIR, my lords, was taken with the thumb impression of a right leg of the victim. The police officer who got recorded the statement,
And whether they were examined, the brother of the deceased and
Lords, they all have stated that she received burn injury while she was cooking food. No one is liable for her death. She was never subjected to any torture, any demand of dowry.
no, but there is in the FIR probably she disclosed that her brother and Bhabi
Milords,
were present.
Milords, they are PW4 and PW5 respectively. The Nitu Devi is the Bhabi, and Milords PW5 is Pawan Kumar is the brother.
What do they say?
They stated, Milords, the deceased was never subjected to demand of dowry, torture. In-laws used to keep well her, and she received fire injury when she was cooking, accidentally when she was cooking food. PW4 and PW5.
No, but your earlier prayer was rejected.
Milords, on Milords, yes, on 5/4/2019, on earlier occasion, the prayer for bail of the appellant was rejected.
So you are in custody continuously since?
Milords, since 9/4/2015.
Lift. IA number. You have filed
Yes.
your objection.
Yes.
IA number 2 of 2021 has been filed. This application has been filed for the release of the appellant on bail upon suspending the sentence during the pendency of this appeal. The appellant stands convicted of the offences punishable under section so and so, and sentenced to imprisonment for life and fine with default clause. Stop. The petitioner is the husband of the deceased. Stop. His similar prayer for bail was earlier rejected by an order of this court dated 5/4/2019, passed on IA number 1 of 2019. By making this application, the appellant has renewed the prayer for bail during the pendency of this appeal. Stop. Pursuant to the opportunity granted by this court for filing a written so-called reply, a reply under the proviso to section 389(1) of the CRPC, such reply has been filed by the state, which is there on record. So, the appellant's prayer for suspension of sentence and his release on bail during the pendency of this appeal is being resisted by the state. So, counsel appearing on behalf of the appellant has argued that none of the prosecution witnesses examined during the course of trial have supported the prosecution's case that any demand of dowry was being made by the appellant after the deceased was married to the appellant nearly 10-12 years ago, 12 years before the death of before the date of occurrence. So stop. He has submitted that the so-called dying declaration of the deceased has not been duly proved. Even the postmortem report has not been
Yes, no, not
Proof.
examined,
Even
not
the-
exhibited, my lords.
postmortem report was not exhibited. So stop. Next. Be that as it may, So the appellant is in custody since 19/4/2015.
9/4, my lords.
Sorry, 9/4/2015. First off, it is being submitted on behalf of the appellant that the appeal is not likely to be taken up for final hearing in near future. Full stop. Next, considering the above submission and the law laid down and the observation made by this court in case of Suddu Kumar, paragraph 19 of which reads as under, comma, a case is made out for the suspension of sentence and appellant's release on bail during the pendency of appeal. Paragraph 19 quote करोगे. So, IA number so and so is accordingly allowed.
Obliged, my lords.